Hello, this is Matt on the Moon Family Sedan channel, and I found this to be rather fascinating and exciting. Attorney Jeremy Hogan found a hint that indicates Judge Torres in the SEC v. Ripple case may believe that XRP is not a security. I'm going to break down exactly why that is, and I got comments from both Attorney Jeremy Hogan as well as Attorney John Deaton on this exact topic. But before going further, I do want to be clear, I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything I say or write. I'm just an enthusiast who enjoys making YouTube videos about crypto-related topics, but just as a hobby and just for fun. All right, so here's a new tweet from Attorney Jeremy Hogan in which he writes the following. In her recent order, the judge cited the Marine Bank v. Weaver case at least 3 times when discussing what a reasonable XRP purchaser believed when they bought XRP issue. It's a Supreme Court case which asks whether the thing sold was commonly thought of as a security. And so I'll just say, I am so thankful for all of the attorneys within our community who break this stuff down, because even reading this stuff, for most of us, including myself, most of us are not attorneys. Reading through this stuff, there's no earthly way that we would understand the implications of some of the stuff that's cited here. And here, Attorney Jeremy Hogan and Attorney John Deaton breaking this down. And so Attorney Hogan shared the screen grab. We'll make it full screen for a second here, which reads as follows. The agreement in question is not the type of instrument that comes to mind when the term security is used, and does not fall within the ordinary concept of a security. And that's from SEC v. WJ Howie Co. case. And SEC v. CM Joyner Leasing Corp. Distinguished. The provision of the agreement giving respondents a share of the company's profits is not, in itself, sufficient to make the agreement a security. Now, to most of us who are not lawyers, again, that might be like a little gobbledygooky sounding, but thankfully they break it down for us here. And so check out what Attorney John Deaton says. He jumps into the thread here and he says, read the language here. A provision in an agreement gave the investors a share of the company's profits. Yet, the court said the provision itself is not a security. That's a major focus of XRP holders' amicus brief. XRP itself is not a security, and neither are secondary sales. So now you can see why this is so substantial. So why might, and this is the key question, why might Judge Torres multiple times be citing this Supreme Court case? Might it be because the decision that it came to, the conclusion of that case, directly relates to whether or not the underlying asset is a security? Methinks the answer is yes. And so, and this is also why I think it's so highly consequential that Attorney John Deaton has done what he's done, and why it's so consequential that all of the amicus briefs were filed, noting, hey, look at us over here with our hands raised. We are an entity that is using XRP. It's not about financial gain. It's not about expectation of profits. We're functionally using it, just like Spin the Bits or Tap Jets, name your company. Pretty damn obvious. But again, all of this seems to have seriously caught the attention of Judge Torres. Highly consequential. This is gigantic. And so again, it's just a hint, but it's a big hint. It's a really big hint. And then Attorney Deaton says, in our brief, I highlighted the character in commerce test and wrote, quote, considering the inherent characteristics of the underlying asset, XRP, is critical before conducting a Howie analysis. And then he cited the case that's relevant, Glenarden Commodities Inc. versus Costantino. And that's from 1974. So considering the characteristics of the underlying asset, again, XRP is critical before you even get to Howie. And again, how does that relate here? Because again, you go back to this case that's cited by Attorney Jeremy Hogan here. Well, by Judge Torres, and then Attorney Hogan notes it here. Again, John Deaton said, a provision in an agreement gave the investors a share of the company's profits, yet the court said the provision itself is not a security. The provision itself, the underlying, it's not. Highly consequential. And then Attorney Deaton also shared this quote. The test, rather, is what character the instrument is given in commerce by the terms of the offer, the plan of distribution, and the economic inducements held out to the prospect, end quote. And then he says, bottom line is that, quote, and then he shares another one, and this is referencing a case, United House Found Inc. versus Foreman from 1975. The quote is, when a purchaser is motivated by a desire to use or consume the item purchased, the securities laws do not apply, end quote. Now that's consequential, so think about that. Attorney Deaton literally shared that. When a purchaser is motivated by a desire to use or consume the item purchased, the securities laws do not apply. And then you have here Judge Torres, having consumed that information, sharing the Supreme Court case, which is talking about the underlying asset itself, like the instrument. Or you could say instrument, that's probably more precise, but it's functionally the same argument. That's a big deal. So it's a hint into what Judge Torres may be thinking here. A really big hint. And Attorney Hogan, I think, agrees based on what he said in response to Attorney Deaton. Attorney Hogan, in response to that, said, after reading the Daubert order, and so pause to note, again, the Daubert order, that's the ruling a few days ago from Judge Torres in which she smacked down a bunch of the SEC expert witnesses. And so Attorney Hogan says, after reading the Daubert order, I think the XRP holders' brief and submissions may turn out to be critical. Exactly, and that's what I was getting at just a couple minutes ago. The fact that there are all of these amicus briefs, all the XRP holders, all the submissions, all of that, people stating why they're doing what they're doing with XRP, well, if you just look at existing law, it's very clear that those could not be securities transactions. It just can't be by the definition of law. And then Attorney Deaton responded to Hogan and said, I'm confident the judge will deny the SEC summary judgment motion as written/requested. When they were forced to abandon their so-called XRP holder expert, whether XRP was acquired for consumptive use is a material fact in issue. That alone requires denying the SEC's motion. And so, folks, this is, again, Attorney Deaton just saying he doesn't see how Judge Torres could possibly grant the SEC's motion for summary judgment. He just doesn't see how the SEC could possibly win as written. He doesn't see that happening. And then Attorney Deaton says, the real question is how aggressive does Judge Torres get in trying to resolve the case without a jury? For example, does she find the instance when Ripple sent a brochure to 100 potential investors in 2014 an unregistered securities offering, but conclude today's sales are not? Good question. And so we don't know exactly how Judge Torres is going to break this all down, but it's certainly possible. There still are possibilities that Ripple could be found to have engaged in some sort of illegal unregistered securities transactions. But again, for us as XRP holders, even if that happens, as long as there's a path forward for XRP and XRP itself is not found to be a security, which would be the right way to approach this, then we're fine anyway. It's not that I want Ripple to go down in flames. Absolutely not. I think they're a force for good within the XRP ecosystem. But I'm just saying, even if they kind of get the shaft in some ways, or if they have to pay some sort of fine, this or that, okay, as long as they can live to fight another day. And then Attorney John Deaton also shared this. Judge Torres allowed me to file a motion to intervene. She could have said no right out the gate. Many experienced lawyers said she would deny my request. She didn't. She then granted us amicus status and ignored the SEC's personal attacks on me. She wanted to hear our perspective. And so now you can see how big of an impact it has had. And maybe you could say, okay, maybe Judge Torres would have come to these conclusions on her own anyway. Maybe. But isn't it a lot more likely that she did because of all of this? I think the answer is yes, because all this information, all this data from all these people, the entities that filed amicus briefs, it's so overwhelming. There's no way she wouldn't have noticed it. But would she have picked up on it otherwise? Maybe. But it's impossible for her to not notice it at this point, right? That's the point I'm making. And then Attorney Fred Rispoli, member of the XRP community, wrote the following in response to Attorney Hogan. He said, this is another reason why I'm not 100% that Ripple cannot win outright. I still think it's a long shot, 10%, but Judge Torres sprinkled a lot of warnings to SEC that a total loss for them at summary judgment is possible. Oh, the anticipation. So there, he thinks that the Attorney Rispoli, even if it's a smaller chance, that Ripple could win at summary judgment. And so, and outside of that, an attorney Rispoli is also, he's one of the individuals, one of the attorneys, along with, including attorney John Deaton, who think that it's more likely now as a result of what happened with the Daubert rulings, that you're going to see a jury trial, actually. And so we really still may see that. It does seem like there's an increased odds of that, but increased odds in conjunction with Judge Torres seemingly understanding the importance of recognizing that the underlying asset itself is not a security, which means if that hint is what we think it is, then in the end, however messy this gets, however long it takes, the ruling is going to include something. If we're taking this hint at the way I think is reasonable to take it, there's going to be clarity for XRP to the positive. There is going to be a path forward. That's why I wanted to make this video. That's what's so exciting about this. There's no guarantees in any of this, but that's a big-ass hint. That really is. That is truly substantial. I'm not a financial advisor. You should not buy or sell anything because of anything I say or write. That would be a very, very, very bad idea. Until next time, to the Moon Family Sedan.